Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. Today we're going to talk about Rachel Tennyson's cases, I should say, because she has two of them going on at the same time. So let's take a look, give an update. Okay, so this is cases in Texas, and so it's in the Northern District of Texas, and you can see that this case right here was filed 5/14/25, and the case number is 325CV01232, and it's entitled Lakeview Loan Servicing versus Tennyson. And as you can see, the judges' names are Sam Lindsay and Rebecca Rutherford. Okay, and you can see the Lakeview filed their complaint for foreclosure on 5/14/25, and so this is a judicial foreclosure complaint that they filed. She has an FHA loan with a partial claim deed of trust, which means they have to get rid of HUD's lien on the property before they can sell it in Texas on a non-judicial foreclosure sale. So this is the route they are taking with people that have defaulted on their loans, probably on no fault of their own. We know that a lot of these FHA loans that they did during the pandemic were to try to help the homeowner by reducing principal, by adding number of months to the loan term. And so in Rachel's case, they took $100,000 from the principal and did the partial claim deed of trust with HUD. So her overall principal balance was actually $100,000 less. But, okay, and then they extended the term from 30 to 40 years, and she thought that would make her mortgage payment lower. And they pretty much convinced her during the pandemic that it would make it lower. That's the only thing they could do to make it lower. But instead, her payment turned out to be actually higher because they upped the interest rate without telling her. So anyway, that's where this is at, this case here. But again, she has another case where she's filing a quiet title action against them in the same court with the same judges. Okay. Now, if you look at this case, you'll see at the very end here, it says, and again, Rachel filed a motion to dismiss on 6/12/25. The judge issued an order the very next day on 6/13/25. telling the other side they had until July 3rd to file a response to the motion to dismiss. Well, guess what? They didn't file a response on the 3rd. And so what happened was on the 8th, which you see here, a notice and an answer to complaint was filed by Rachel. Let's take a look at that answer and notice of non-response. So this is the notice of non-response since they didn't respond to the judge's order. And it's pretty simple, straightforward. It says defendant Rachel Tennyson's notice of plaintiff's failure to respond to the two defendants' motion to dismiss. Comes now, defendant Rachel Tennyson pro se and respectfully notifies the court that plaintiff Lakeview Loan Servicing has failed to file a written response to defendant's Rule 12 motion to dismiss Doc 7, which was due on July 3rd, 2025, pursuant to the court's order, Doc 8. As of July 7th, no response or opposition from plaintiff has been filed on the docket. Defendant requests the court take notice of plaintiff's failure to respond and consider defendant's motion to dismiss accordingly. Okay, and then there's also a certificate of service sent to the other side. Okay, so what does this mean? Well, it means she's telling the judge to take notice of this, of the fact they didn't file. And then she also filed an answer, which is what this looks like here. And it says defendant Rachel Tennyson's combined answer, affirmative defenses, and counterclaims. So you might want to ask, well, why would you want to put this on the docket if the case is going to get dismissed? Well, here's an answer. Because if it gets dismissed, it's dismissed against Lakeview Loan Servicing, she can still proceed with her counterclaims against them, which is what she's doing. So she's preserving her rights by putting these claims in with an answer and counterclaims. Since the judge has not ruled yet on the motion to dismiss, the window is considered open for her to do this, which was very strategic for her to do. So she filed her answer, and basically the answers are pretty much admitting or denying certain things in the actual complaint. And then the good part, though, is coming right up here with her affirmative defenses. And again, paragraphs 1 through 21 of this answer are incorporated herein by reference as if fully set forth. And that has to be done on each section to comply with proper formatting. Anyway, she's arguing they failed to state a claim, improper party and servicer identified. They misidentified the loan servicer as Nation Star Mr. Cooper instead of Loan Care, which is the correct servicer, rendering allegations inaccurate. Lack of proper service. She was never served a copy of the complaint as required by federal and Texas law, non-compliance with Texas foreclosure laws. So they haven't complied at all. Existence of a junior lien. HUD holds a valid junior lien which takes priority and prohibits plaintiff's foreclosure without addressing the lien holder's rights. Failure to mitigate damages. Plaintiff has failed to take appropriate actions to mitigate damages and avoid foreclosure. Unclean hands, waiver and estoppel, violation of federal laws like RESPA, other defenses, and of course she reserves the right for any defenses not disclosed during discovery. Counterclaims. Now this is the part that I say matters, because even if it gets dismissed, they still have to answer these counterclaims, which in fact she becomes technically the plaintiff and they become the defendant when it comes to these counterclaims. So just so you know. Counterclaim 1, failure to comply with 28 U.S.C. 2410 requirements. And this is kind of a big deal. Plaintiff Lakeview Loan Servicing initiated this foreclosure action invoking federal jurisdiction under 28 U.S.C. 2410 based on the asserted interest of the United States through Secretary of Housing and Urban Development in the property. Section 2410 provides a limited waiver of sovereign immunity to permit foreclosure actions involving the United States property interest, but also imposes procedural safeguards designed to protect all parties' rights, including the junior lien holder, HUD, and defendant. Plaintiff has failed to comply with these mandatory statutory procedural requirements, including but not limited to proper notice to all lien holders and defendants, adequate service of process on defendant, demonstration that defendant holds the senior lien and that HUD interest is in junior and subordinated. Plaintiff's complaint also contains inaccuracies and misstatements, such as incorrectly identifying the loan servicer as Nation Star, Mr. Cooper, instead of Loan Care, which demonstrates a lack of due diligence. Defendant asserts that plaintiff failure to satisfy requirements of 28 U.S.C. 2410 renders the foreclosure action improper and invalid. So these things are basically more reasons to have it dismissed. Okay, counterclaim 2 would be declaratory judgment, which she pretty much used in her quiet title action. This information, same information that she has in her quiet title action, she used for her counterclaims. And as you can see here, she's asking for the judge to declare that whether defendant's title interest in the property remained clouded due to conflicting payoff figures, improperly rounded documents, recorded documents, and suspect notarizations. Whether any party currently holds a lawful and enforceable interest in the subject property or promissory note. Whether the loan modification agreement dated February 23, 2023 is void or voidable due to fraudulent inducement, lack of authority, and or misrepresentations. Okay, so basically she's asking for relief, and then the next section would be counterclaim 2, which is a quiet title. Again, she pretty much copied and pasted a lot of this from her complaint for her counterclaims. She had to, of course, change plaintiff to defendant and vice versa. Talking about how the assignment is void. Counterclaim 4, violation of the FDCPA. As we know, Lakeview is a debt collector within the meaning of FDCPA, and defendant is a consumer, and they violate the FDCPA by misrepresenting the amount and legal status of the debt. And unconscionable things to do, with the debt. So deceptive means of debt collection is what they're doing. And there's the relief requested. Counterclaim 5, negligence. As a mortgage servicer, plaintiff owed defendant a legal duty of care to exercise reasonable diligence, accuracy, and good faith in the performance of its servicing responsibilities. And again, she goes over everything they were negligent about. And again, this stuff is also from her quiet title complaint. Relief requested, again, same thing. Counterclaim number 6, fraudulent inducement. Okay, and so they basically, the gist of this one is specifically plaintiff fraudulently induced defendant by misrepresenting and omitting critical facts about the terms and consequences of the proposed loan modification agreement. But it made her payment higher, as you can see in this next paragraph. Plaintiff falsely represented to defendant that the modification would reduce her monthly mortgage payments. In reality, the modification increased her monthly payment from approximately $962.75 to $980.13, despite a significant reduction in principal balance. And also, length of the term should also have made it lower. Now here it is. Plaintiff failed to disclose that the modification included an interest rate increase from 3.625 to 6.625, a material change that directly contributed to the unexpected increase in defendant's monthly obligation. Again, this is fraud by inducement on their part. She's got plenty of evidence to argue this, definitely. And then counterclaim 7, violation of RESPA. She did send QWRs, which they totally did not answer, the QWRs like they should have. Instead sent her conflicting information responses. All right, and then let's see, counterclaim 8, breach of contract. Again, this is from her quiet title. She's arguing all these things. They're not going to get away with any of this, guys. Counterclaim 9, violation of Texas Deceptive Trade Practices Act. Okay, so she's gone through all her, I think that's all of them. Yeah, preferably. Okay, so now you've seen her answering counterclaims, so you can see she's going after them with both barrels. And if you look and compare this with the other one, and you can see this is her first case. This is her quiet title action, which is 325CV00661. Okay, Rebecca Rutherford is the judge on this case. And you can see that she filed her quiet title action on March 19, 2025. And then you can see how this has gone through. The last thing filed was June, which was a notice that she filed letting them know, judicial notice about the forum shopping that Lakeview is doing with other cases where they don't even serve the parties. They just let it sit. And hopefully we'll get a default judgment by letting it sit. And they can't be doing that. So anyway, you can see that it's going to sit. I mean, once you've gone through motions to dismiss and oppositions, it usually sits for about 6 months until the judge writes an order. Okay, guys, I hope this information has been interesting to a lot of y'all fighting foreclosure. What she's doing, fighting back, is very aggressive, but sometimes you have to be aggressive going after these banks. So if you have any questions, you can also leave a comment or send me an email. My email address is foreclosurehelp777@gmail.com. I hope everyone has a blessed day.